This one mistake might cost Blake Lively her entire case against Justin Baldoni. For months, she paraded around as if her lawsuit was going to be the trial of the century, the kind of case that would make headlines and cement her as some crusading Hollywood heroine. But the reality is a lot less glamorous. The mistake wasn't a damaging email, it wasn't a hostile witness, it wasn't even a smoking gun from Discovery. It was a deadline. A simple, straightforward filing deadline that her legal team let slip right through their fingers. That one lapse might be enough to gut the most important part of her case before a single witness ever takes the stand. Baldoni's lawyers didn't need to stage some dramatic courtroom ambush or uncover secret recordings to score this win. All they had to do was wait. They sat back while the calendar did the heavy lifting, letting Blake and her attorneys run out their own clock. Now they're positioned to walk into court and ask Judge Liman to slice out her biggest claims without even touching the evidence. She wasn't out-argued, she was out-timed. And that's the most humiliating way to lose, not because the other side had more facts, but because they had more patience and knew the rules better. Blake thought she was building a blockbuster. What it looks like is a setup. She walked into a trap that anyone who has ever filed a California claim should see coming. The Fair Employment and Housing Act, better known as FEHA, was her big weapon. That law is how you bring the splashy harassment and retaliation claims. It is the engine that made her complaint look like it could run into 9-figure damages. Here is the catch. FEHA has a strict rule. You have 300 days to file with the California Civil Rights Department. Miss that window, and the claim is gone. Not weak, not questionable, gone. So what did Baldoni's lawyers do? They did not rush in with an early dismissal. They did not throw a tantrum in the first round. They waited. They let the days tick by. 200, 250, 299. Then, when the window closed, they moved. They knew exactly what they were doing. Now, those harassment claims are not just shaky. They are toast. Not on the merits, on timing. It is brutal, it is surgical, and it makes Blake's legal team look like amateurs. This is not some technicality. This is the rulebook. You do not respect the clock, you do not get to play. And that is what makes this sting more. You can spin evidence, you can argue credibility, you cannot spin missing the deadline. It is like showing up to the Oscars a week late and wondering where the carpet went. Worse, her whole case leaned on those claims. Pull them, and the house of cards tilts fast. So what is left? A couple of contract gripes and a retaliation count under Title VII of the Civil Rights Act of 1964. And let us be real, that retaliation claim looks like wet cardboard. Title VII retaliation means real job harm. Termination, demotion, a pay cut. Blake had none of that. She was not fired, she was not demoted, she did not lose pay. Her idea of retaliation is bad press, scheduling headaches, and reputational noise. That is not retaliation, that is Hollywood. Even if you pretend it counts, there is the gap. 15 months between her complaint and the supposed retaliation. Courts hate long delays, they kill causation. They make it look like you are forcing a story that is not there. Judges look at 15 months and see a reach, not a case. You can try to sell it to the press, but you cannot sell it in federal court. The only thing that looks retaliated against is her ego. The California add-ons do not look better. Section 51.9, the California Labor Code whistleblower statute, which is Section 11.0.2.5, and her shiny Section 47.1, the so-called content creator law. She tried to drag them all into New York federal court and pretend California rules run everywhere. Statutes do not travel unless they say they do. These do not, which gives Judge Liman every excuse to cut them. If he applies the law as written, Blake's California arsenal vanishes. Geography does not bend for a press tour. Even if Liman felt generous, California courts themselves are strict on extraterritoriality. If the statute does not say it reaches beyond California, it does not. So the ask here is not just help from a New York judge, it is inventing California law that is not on the page. Bold, sure, reckless too. It reads like a bet that fame can convince a court to color outside the lines. That is not how any of this should work. What might survive? Maybe a hostile environment claim under Title VII, that one has not been fully tested yet. Maybe the nudity rider and the contract disputes, not flashy, still alive. Maybe a defamation or a conspiracy count if the judge feels generous. Out of 15 counts, she could limp forward with 3 or 4 scraps. That is not a crusade. That is leftovers. She walked in with a red carpet gala. She walks out with Olive Garden. Now, the judge. Do I trust Judge Liman? Not even a little. This is the same judge who has tossed her lifelines before. The law is clear here. That does not mean he will follow it. He has surprised me, and not in a way that built confidence. I hope he applies the statutes and the deadlines. I hope he trims this to the nothing burger it deserves, but hope is all it is. So here is my reality check. The calendar trap is powerful, but the other side can argue for equitable tolling. They might claim the 300-day FEHA window paused because of internal investigations, agency back and forth, or a continuing violation theory. Some judges buy that. I cannot promise a total kill on timing until the court says it. California does not always stop at the state line either. If a contract has a California choice of law clause, or if the conduct was directed from California by a California company, a judge can find enough nexus to keep a few California counts alive. That is the weak spot in the geography argument, and I know the other side will scream nexus all day. Title VII, retaliation is broader than most people think. The Supreme Court standard asks whether the employer's actions would dissuade a reasonable person from complaining. If Blake threads her story as blacklisting, lost opportunities, or PR sabotage tied to employment control, a court could call that materially adverse even without a firing or pay cut. I still think it is flimsy, but I cannot ignore that the standard is wider than I like. The 15-month gap hurts causation, but it is not an automatic death sentence. If she claims a pattern or points to intervening acts that link the chain, some judges let retaliation claims survive early motions. That would drag me into discovery, and discovery means more headlines, which is exactly what I do not want. Section 47.1 is brand new, and judges get weird with first impression statutes. Liman might dodge by keeping it alive for a little while, maybe ask for limited discovery, or even punt a question to a California court. That drags time, raises costs, and hands her a talking point. I cannot overpromise on that one. Even the contract counts, and the nudity rider could survive. They are not flashy, but they pry open discovery into production decisions, edits, and internal communications. Even if the law favors Baldoni's side, the discovery chaos can feed Blake's narrative and muddy the waters. Defamation and conspiracy are another headache. They look weak, but pleading standards are low. If any of those hang around, I am staring at privilege fights and more subpoenas over who said what. And of course, Judge Liman. I do not trust him. That is why I say might and looks like instead of declaring victory. He can slice the case in a way that saves the pieces Blake cares about most. I hope the law boxes him in this time, but I am not selling certainty when it comes to him. So where does this leave Blake? With a lawsuit that shrinks by the day, with a judge I do not trust, who may finally be forced to follow rules he cannot ignore. With a defense team that played the long game and made her trip over her own clock. And with the humiliation of knowing she was not undone by a conspiracy, she was undone by herself. Blake wanted her day in court, missed the deadline, and that day might never come.